None of us like accidents, whether we're involved in them or we know someone who has been involved in them. And this is no more particularly so when the accident has caused a traumatic brain injury. These people who suffer from these kind of injuries often have no legal capacity. They don't have the capacity to make decisions. And what happens then, they will need to have a litigation guardian appointed to make those decisions. Suddenly they're left with this decision, what do I do now? I have to make some choices around how this compensation is to be paid out over time, and that is generally done through trusts. And here today to help us work through how you can be involved and what you need to know about these trusts are Brian Pashen and Jane Bowes. Welcome.
Thanks, Ashley.
Hi, Ash.
Okay, so let's start with you, Brian. We know the situation. Let's just say son's been injured in a tragic accident, suffered a brain injury, needs guardianship, and settlement's due for the compensation payout of $3 million. What's the first step that you would do?
Well, we need to determine who the guardian is going to be and how those funds are going to be administered by that guardian.
And Jane?
Step one, Ash, is the settlement funds must be sanctioned by the court.
Okay, Jane, who is involved?
Who's involved, Ashley, is the litigation guardian, who's my client, and they're providing instructions throughout the claim, and the insurer on the other side, as well as the courts who will sanction the settlement.
Okay, so once we've established who, so Brian's got some, the who, there's what type of trust and who the party is. Jane's got a litigation guardian, she's got QCAT, and she's got the injured party. We move on to step two as we say, okay, what are the facts surrounding the setting up of this trust? So Brian, what would happen there?
Well, if you're setting up a private trust, you would need to look at who the trustees are going to be, the investment of the funds, the requirements for the investment of the funds. Obviously, the beneficiary will be the disabled person, but in addition, you need to look at what's going to happen when that disabled person dies, to what's happening to the remainder of the funds on the death of the disabled person. So there are a number of factors to take into account. And
so Jane, what are the facts that you need to consider?
So the facts, Ashley, are that we've just settled a claim, and often with our brain injured clients, the quantum is quite high, and now we need to look at getting that claim sanctioned by the court, and then a trust must be set up to take control of those funds.
Okay, so we move on now. So we've got the pieces of the jigsaw puzzle out on the table, which are who are all the parties involved and what are the laws and the facts that govern how those pieces should be put together. And so the next thing is we say, okay, what is the client looking for? What's the objective of the client in this situation? And in this case, let's say the client is the litigation guardian who has the injured party's best interests at heart. Brian, what would the objective be?
Well, the objective is to provide for the disabled person in the long term in the most effective and efficient way.
Yep. Jane?
Ashley, what the litigation guardian's looking for from the lawyers is a quick resolution through the courts of the sanctioning of the funds.
Okay, so once we've got that, so we know we want a quick resolution from you, Jane. We want a fair resolution from you, Brian. Pretty much the same thing. What are the obstacles? What do we have to consider now to move forward? Brian, what would be some of the considerations that you would need to make now?
Well, you need to determine who the trustees are going to be and whether they're appropriate persons to have as trustees. You need to determine the amount of the funds and what annually the requirements for expenses are for the disabled person, and how those funds will be invested to to earn the income that is required.
Okay, and Jane?
So the obstacles are that, firstly, working out or making submissions before the court as to whether or not the funds should be handled by the public trustee or the private trustee. Once that's handled, then the trustee can appoint further lawyers to work out how to set up different trusts to best manage the client's funds.
So if you need to have your lawyer make submissions to the court about the appointment of a trustee, Jane, what's the checklist that you've got? I believe you do this on a case-by-case basis.
We certainly do, Ashley, and we do have a checklist in place to ensure that this process is seamless. So depending on the settlement amounts and the client-specific instructions, we will look at making submissions before the court, whether it will go into a public trustee, whether it will be handled by the public trustee or more appropriately by a private trustee. You'll find that in our cases where the settlement amount is quite significant, most of the time, depending on the client's instructions, the submissions before the court would be that they are appropriately handled by the private trustee.
And Brian, throwing over to you there, we're talking about lawyers making submissions. In a hypothetical, you're working with Jane on a particular case and you decide that you need to have a lot of control over the way that money's spent. What controls would you suggest be put in place?
Well, just going back, I agree with what Jane said, that you need to determine whether the public trustee or private trustee is more important. The controls are mainly around the investment and also in deciding which one to establish, you need to look at the cost involved in the public trustee or a private trustee and which one is more appropriate in the circumstances.
Brian actually raises a good point there, Ashley, and it's often an argument we'll receive from the insurer is that the private trustee is too expensive. Often the terms of our settlement will be that the insurer is responsible for the trustee, the cost of the trustee. So the insurer will argue that they would like the funds to go into the public trustee, which is more cost efficient, and often it's not really within our client's best interest. So we would put before submissions to the court that while it can be expensive with the private trustee, that is the best solution for the client.
So I guess at the end of the day, if we develop these checklists that allow a client or a litigation guardian to go through a step-by-step process that gets them to consider cost, it gets them to consider the control, and it gets them to consider the ease of operating of this trust, they should be able to come up with an idea of the way that they want to go because they're the client. Is that right?
That's exactly right, Ashley.
Yeah, couldn't agree more.
Okay, so hopefully if you have understood this, that we've talked today about trusts for litigation guardians looking after money for injured people, particularly those with a brain injury, and we've produced a checklist and a flowchart here together with Brian and Jane that can take you through that process where you'll need no involvement from them at all to come up with a more informed decision about what you want. So thanks Jane and thanks Brian.
Thanks Ashley.
Thanks Ashley.